Well, hello there and welcome to our Employment Law Q&A webinar today. This webinar is hosted by New Entry Sustainable Farming Project and the Legal Food Hub. The presenter today will be Beth O'Neal, a partner at Conn Kavanaugh, Rosenthal, Peach & Ford. And I am Kristen Aldrich with New Entry Sustainable Farming Project. I'm just going to start with a quick overview. I'll be serving as the webinar facilitator and host today. And we'll be facilitating the questions. So just to get started, wanted to orient you all to the WebEx platform. In case you have any difficulty with your audio settings, you can find the controls in the upper left-hand corner. And also for the questions, which this webinar is entirely just question and answer. We did collect some in advance, but definitely welcome you to ask questions throughout. And to do so, we invite you to use the chat feature, which is pointed out here in the upper right-hand corner, where you can send a message and actually set who it's going to be sent to, so that it's either sent to everyone so that all can see, or even if it's sent to just myself, we'll make sure to announce that for Beth to respond to. And so also wanted to mention that following the webinar, we'll be sending you all the recording of the presentation today, along with a link to an evaluation for your feedback, as well as a link to different resources relevant to the content today. So for a quick overview and some context about New Entry and this webinar that we'll be providing today. So New Entry, in addition to having our own incubator farm training program and food hub and CSA that are based here in Eastern Massachusetts, we also house and facilitate national networks of beginning farmer training organizations. So the two networks that we facilitate are the National Incubator Farm Training Initiative and the Ag Apprenticeship Learning Network. So these are both communities of practice whereby we can share information, best practices, and resources to folks who are operating land-based farmer training programs across the country. So we share information on issues affecting farms and organizations that are running apprenticeships and land-based farm training programs. So the Q&A today will offer the opportunity to dig into a lot more of the ag employment law questions that might affect your operations. So we work with a number of wonderful partners and on these various projects, including the Conservation Law Foundation. And so I want to give them an opportunity to talk a little bit about what they do and some of their great work. So I'll now turn it over to Jenny Rushlow, the Director of Farm and Food at the Conservation Law Foundation.
Great, thanks so much. This is Jenny. Thank you all for participating in the webinar today. So the Legal Food Hub is a project of Conservation Law Foundation. CLF is a New England-wide environmental advocacy organization, and one of our program areas focuses on food and agriculture. And the Legal Food Hub is a part of that. It provides pro bono legal assistance to farmers, food businesses, and the organizations that support them. And we operate as a service where we pair folks that need legal services with attorneys at private law firms who have agreed to provide their legal services for free. And this webinar is a part of that program. In addition to providing direct legal services, we also provide educational opportunities like this, both for Legal Food Hub participants like farmers, as well as educational opportunities for attorneys to develop more legal capacity on the issues where the legal community needs to be working with farmers and food businesses. So for our program today, we're very fortunate to have Beth O'Neal as our presenter, who is a partner at Conn Kavanaugh, Rosenthal, Peach & Ford in Boston, and she is an expert in employment law. Beth presented a webinar on Massachusetts employment law for farmers earlier this year, and that's available on the Legal Food Hub website's resources page. And the Legal Food Hub website is legalfoodhub.org. We're really lucky to have Beth here today, again, to share her expertise with us. As a reminder, and we shared this reminder earlier, but I think a few folks signed up for this webinar after that was shared. Beth is an expert in Massachusetts and federal employment law, and we know some of you are joining from out of state, and that's fantastic, but we just wanted to remind you that she will be getting into some specifics. She may be getting into some specifics related to Massachusetts that could be a little different in other states, so that's just something to keep in mind. Great. So with that, I'm gonna turn it over and we'll get started.
Terrific. This is Beth O'Neal, now speaking, and I'm very happy to be here. Apparently this is a new adventure for both Legal Food Hub and New Entry in terms of having a pure question and answer session. As had been mentioned, I had done a webinar, I think it was back in March, and then some of my colleagues here at the firm have been doing programs elsewhere, and we had produced an employment law guidance for Massachusetts farmers, which I understand is available to folks. But the program today will be strictly question and answer, and I had mentioned to Kristen and Sarah Dewey from Legal Food Hub before we began that hopefully none of you will stump me, but if you do, I will let you know where I think you could perhaps locate or find a more definitive answer to whatever question you have asked. We did solicit questions before this webinar began, and I believe that what Kristen is going to do is to start reading from those questions that had been submitted previously. I will respond to them, but we very much welcome your questions in real time and would appreciate your posing them because this may be your only opportunity. And hopefully, as I said, I'll provide you with some good and helpful information. So, Kristen?
Wonderful. Thanks so much. So I'm going to walk through the various questions that were submitted in advance. I tried to kind of categorize them into different topic areas, so hopefully it will help the conversation flow a bit here. But I'll just go ahead and start reading through these questions one by one. So first, are part-time farm employees eligible to unemployment insurance benefits if the position has ended?
So the answer to that is perhaps. And it doesn't matter if it's a part-time farm employee or a part-time employee employed elsewhere. So if an individual who was employed part-time has earned sufficient monies in the base wages that are utilized by a division or department of unemployment insurance, and they have worked enough hours in that base period, they very well may be eligible for unemployment benefits. Unemployment benefits are most certainly something that the state in which the employee resides is in charge of. So merely because an employee was part-time does not mean that they are automatically ineligible for unemployment benefits. They very well may be eligible. In Massachusetts, the Division of Unemployment Assistance, which is called the DUA, has a very good website, and I would recommend highly to you if you have any particular questions related to when and under what circumstances your employees may be eligible for unemployment, that you visit the website.
Great. Okay, next up, at what point is it mandatory to offer health insurance to your employees?
That is also a very good question, and it's governed by both federal law, which is the Affordable Care Act, and if you as an employer are not subject to the provisions of the Affordable Care Act, it may be the case, as it is in Massachusetts, that you will have to comply with the Massachusetts law relative to an offer to your employees of coverage under a group health plan that you as the employer have available to your employees. There is a wonderful website that is run by the Mass Health Connector that will describe for you what are the requirements for coverage as a covered employer. Also, if you have an agent that you deal with in terms of your other insurance, I would recommend to you that you speak with your insurance agent who may be able to assist you in determining what law you are covered by, whether it's the Federal Affordable Care Act or the state, and in Massachusetts, it's the Massachusetts law administered by the Mass Health Connector. If your operations are located in a different state, you will certainly want to seek counsel, advice, and guidance as to whether the law of your particular state has its own requirements for health insurance being offered to employees.
Great, thank you. Another question, someone wrote, I'm uncertain about unemployment, sick time, tax filings. If I'm using a payroll company, what questions should I ask?
Well, typically payroll companies are going to track employees' hours for purposes of certain benefits that an employee is entitled to. So, for example, under a fairly newly enacted Massachusetts law, every single employee, whether they're part-time, full-time, seasonal, temporary, you name it, they are entitled to earn sick time under a recently enacted Massachusetts law. Depending on the number of employees that you have will determine whether or not that sick time that they're entitled to earn is going to be paid or unpaid. If it's to be paid, that's where the payroll company will come in, because they will track the number of hours that the employee has worked, obviously, and they will also track for you the number of hours that the employee has earned in terms of their sick time. So under Massachusetts law, an employee earns 1 hour of sick time for every 30 hours worked. If you have 11 or more employees, those employees earn paid sick time. So I think that your payroll company should be able to tell you whether they have the ability or the capability of tracking those hours for those specific benefit plans. I think that they ought to also offer services with respect to the filings that you're required to make as an employer with the agency, the state agency that requires that you pay unemployment insurance benefits. I'm not sure if they would also handle tax filings, but those are the types of questions that you would want to ask the payroll company. I know a couple of the larger payroll companies do all of the above. For example, ADP, I'm told, takes care of tracking sick time benefits and paying unemployment insurance premiums and tax filings. So I would, if I were you, ask the payroll company what are the advantages of using them as opposed to somebody else. See if they have something that they could send you in writing, and then you can compare the services that are offered by payroll companies and make an informed decision.
Great, thank you. Next question has a few parts. Do I need workers' compensation for apprentices? What do I need to record in terms of man hours for my apprentices? And is working at a farmer's market non-exempt work time?
Okay, so every single employee, which would include a paid apprentice, and we will probably get into a bit later when and under what circumstances you're required to pay an apprentice, and I will preview that for you. It's always. But every single person who is being paid as an employee, which would include an apprentice, is entitled to be covered under a workers' compensation policy. And the failure by an employer to carry workers' compensation insurance, if they're otherwise obligated to, can be very dire and significant. So, for example, if you fail to have workers' comp insurance, and you should have, or alternatively you have it but you didn't cover a particular employee, the employer could be legally liable or responsible for the benefits that would have otherwise been payable to the employee who should have been covered, and also, and this is really a very important ingredient, the employer could be responsible for the medical expenses that otherwise would have been paid for the benefit of the employee under the workers' comp insurance. In addition to that, under Massachusetts law, the owners of a company that do not have, or the company does not have workers' comp but should have, the owners of the company can be individually and personally liable if the employer failed to have workers' comp insurance and they should have. So it is very important in dealing with your workers' comp insurer to make sure that you ask the questions about who should be covered under your workers' comp policy and make sure that you comply with those responses that you get. The second part of the question was, what do I need to record in terms of man hours for my apprentices? Whether the worker is an apprentice or a regular worker, as an employer, you are absolutely obligated to keep track of the hours that each of your workers work on a daily basis and then on a weekly basis. And the reason for that is because, putting aside for the moment whether the worker is an apprentice or a regular worker, employees generally, unless they're exempt, and we will talk about that today, if they are not exempt from overtime, you are required to pay workers an overtime rate of pay, which is time and a half, for all hours worked in excess of 40 hours. Now, how will it be determined whether an employee worked over 40 hours? It will be determined based upon the records that you keep. For rank and file employees, I recommend some sort of a time clock that everybody's got to use, or at least some sort of a time sheet. If you've got the ability to have employees logging in on a computer, and obviously the computer system is operating the way it should, you can track the hours in that way. And the reason it's so important is this. If you have a worker or an employee who was entitled to overtime and they were not paid overtime, and you as the employer failed to keep appropriate records regarding the number of hours that your employee worked on a daily and weekly basis, that's your obligation to keep those records. And if you don't, typically what the employee says goes. And by that I mean, if the employee says, well, I worked an average of 10 hours every single day, 6 days a week, if you haven't got the documentation to essentially rebut that, generally speaking, what the employee says goes in terms of the number of hours that the employee worked. So it's critically important for you to have records and to track the number of hours that your workers work. And now the third part of that question is whether working at a farmer's market is non-exempt work time. So that's an answer that will take a little bit of time, and I want to sort of set up what is important for you folks to know. So as between state law, which obviously includes Massachusetts, and federal law, the rule is whatever provides the more generous rate of pay for your workers or employees is the law that you need to follow. So under federal law, minimum wage is a very small amount of money. It's $7.25. Under Massachusetts state law, minimum wage is $11 per hour. So as between federal law and Massachusetts law, most certainly Massachusetts law would apply to a Massachusetts employer. There is an exemption, however, for Massachusetts agricultural and farm workers. And under a Massachusetts law, such workers are entitled to be paid what's known as a sub-minimum wage. That sub-minimum wage, though, is $8 an hour, which is better than the federal minimum wage. So if you are a Massachusetts employer and you have employees that are employed in agricultural and farm work, you are permitted to pay that employee a sub-minimum wage of $8 per hour. You are also entitled to not pay that worker overtime. So the most important question would be, well, what's meant by agricultural and farm work? Now, under the Massachusetts statute, if an employee labors, works on a farm with respect to the growing and harvesting of agricultural, floricultural, and horticultural commodities, they're viewed as a farm worker. That's not a lot to go by. So what we typically will do is also look to the federal definition of what constitutes agriculture. And typically what it includes is farming in all of its branches. It includes cultivation and tillage of the soil. It includes dairying. It includes the production, cultivation, growing, and harvesting of agricultural or horticultural commodities. It includes the raising of livestock, bees, fur-bearing animals, or poultry, and any practices performed by a farmer or on a farm as incident to farming operations. So, would working in the field, including planting and harvesting crops, constitute agricultural work? Yes, it would. Would preparing the harvested crops for sale? Yes, it would. Would operating a tractor or other machinery on a farm? Yes, it would. But sort of ancillary or sideline duties or tasks, such as, for example, working at a farm stand, selling the vegetables, for example, that are raised and harvested on the farm, that would not be considered as agricultural work. So you would have to pay the employee who performs those types of duties at the Massachusetts minimum wage of $11 per hour and not the sub-minimum wage of $8 per hour. If your worker made jelly, for example, with berries that you grew and harvested on the farm, that would not be considered agricultural work either. And then if you have a worker who works in agritourism, for example, you operate hay rides or corn mazes, that worker would not be considered as engaged in agricultural work. So if your worker is on the farm doing farm-type work, harvesting, planting, operating tractors, that's all agricultural work. If they're doing the ancillary work of the type that I described, that would not be agricultural work, and those workers would need to be paid the minimum wage of $11 per hour.
Great, thank you. And then back to the workers' comp piece, we had a question come in. What happens if the person is a contractor? How does that affect workers' comp?
So contractors are not eligible to be covered under workers' comp policies. However, if you have a contractor, and by that I assume what you mean is an independent contractor who you pay a particular amount of money to and then issue them a 1099 tax reporting statement, it very well may be that you have misclassified that individual, and they really ought to have been classified and treated as an employee. And if you have misclassified them, treating them as an independent contractor when they really weren't an independent contractor, if that person is not covered under your workers' comp policy, perhaps they should have been, and then all the the results that I spoke of before as to what might happen if you didn't have workers' comp insurance or you didn't cover somebody that you ought to have would be triggered.
Great. And then I think related in some ways to that, another question regarding contractors. Someone wrote in, please share about the legalities to hire labor for farms as contract, 1099 miscellaneous expense, and when do we have to have employees?
So under Massachusetts law, it is extraordinarily strict as to when you might classify and treat somebody as an independent contractor. And it is the obligation of the employer to prove that a person is legitimately treated as an independent contractor. So let's start at the beginning, and by that I mean that there's a presumption under Massachusetts law that every single worker who performs work is an employee and must be treated as an employee. Now, what does that mean? It means that they're entitled to minimum wage. It means that they may be entitled to overtime. It means that you've got to pay Social Security on their behalf and deduct taxes from their pay. So the presumption under Mass law is every single worker who is performing a job is presumed to be an employee. Now then, it's up to the employer to prove otherwise. And under Massachusetts law, the standards for proving otherwise are very difficult to do. And it's a three-part test to demonstrate that the worker should be classified as an independent contractor. And the three-part test will be set out in the materials that you will receive. But one of them is the most difficult of all to prove. And that is, you have got to demonstrate that the work that the worker is performing is outside of the usual course of the business of the employer. Now, what does that mean? I will give you an example to make the point. So I work in a law firm, and we practice law. That's our business. So the receptionist and the secretaries and the legal assistants and the lawyers and even the IT guy, they're all performing work that is consistent with the usual course of our business of practicing law. We also, though, have plants here in the office, and we're not in the business of taking care of plants. We're not in the business of watering them, of clipping them, or of taking care of them. So we hire contractors who come in and take care of the plants. It is perfectly appropriate and legal that we would hire those folks as contractors, not as employees. So really the nature of the job that the independent contractor is performing for you has got to be really outside of the scope of the usual business that you conduct. And of the three tests, that is always the one that trips most employers up.
Great. Yeah, and I think related to that, the next question is around kind of classification of employee versus contractor, and particularly how it applies to apprentices. So someone wrote in, for employees, we must withhold employee and / employer taxes. For contractors, we don't. We view apprentices as neither employees nor contractors. We've paid apprentices as employees and paid them stipends like a contractor. So what is recommended?
So what I recommend is that you treat an apprentice as an employee. And by the way, you may be permitted to pay your apprentice what's considered a sub-wage, which would mean just at minimum wage, and then they gradually can earn more as they are going through their apprenticeship program, but under both Massachusetts law as well as federal law, if you are going to employ apprentices, you must register and have approved on a federal and state level your apprenticeship program. Now, the requirements for obtaining approval at both the state and federal level are not easy. You still typically must pay minimum wage to your apprentices, and as I indicated, you can then gradually increase their pay as they become more proficient at what it is the program that they're an apprentice under. You also possibly have to pay them overtime. Now, what is a positive feature of seeking to register and have your apprenticeship program approved is that applications for apprenticeship programs can be submitted by a group or an association of businesses. But the particular requirements of a program that you seek to have approved are very detailed and very onerous. You can, under Massachusetts law, if you have an apprenticeship program, you have to devote a minimum of 150 hours per year of instruction to your apprentice on technical matters. You've got to have a detailed written plan covering the employment, the training, and the supervision. The instructor under the apprenticeship program must receive training on teaching techniques and adult learning. As I indicated before, typically you need to have a starting wage of not less than the applicable minimum wage. You might be able to obtain a special certificate based on a determination that a sub-minimum wage may be necessary so as to ensure employment for those folks that are apprenticing. You have to have periodic written reviews of your apprentice progress. You have to have a detailed written apprentice agreement, and you have to have meticulous record-keeping requirements, and then you may have periodic audits that are undertaken by either the Massachusetts or the federal agency to whom you submit your apprenticeship program for approval.
Great, thank you. And then another kind of distinction in terms of classification, what are the laws around volunteer labor?
Okay, so a volunteer is typically somebody who is not being paid for their work. So it's a non-paid volunteer. There is no such thing as an unpaid volunteer for a for-profit business. So if you are operating a for-profit business, you cannot have unpaid volunteers working in your for-profit business. The only time that you're permitted to have an unpaid volunteer is if the volunteer is doing work for a non-profit entity. And then there are 6 factors that need to be taken into consideration in terms of whether the person really is a volunteer, and you do not have to satisfy all 6 factors, but you need to consider them. So, for example, what is the nature of the entity that is receiving the volunteer services? Is there some sort of an expectation by the volunteer that they will receive any sort of pay or benefits from their work? Is the volunteer activity less than the individual's full-time occupation? Whether you have regular employees who are going to be displaced by the volunteer. If that in fact is the case, that person cannot come on as an unpaid volunteer. Whether the services are offered freely, without pressure, without coercion, and then whether the services are of the kind typically associated with volunteer work. So let me give you an example. If you are, in fact, operating a nonprofit farm or some part of the operation is nonprofit, for example, if you operated some sort of a food kitchen, you could have somebody who comes in and volunteers to stock the shelves or serve the food or help those who come in and are looking for either food or meals. That person likely could be treated as an unpaid volunteer. But on the other hand, if you've got somebody driving your truck, bringing your food products to the location where you serve your customers, that individual who is otherwise employed by you would likely not be able to be classified as an unpaid volunteer. So the fact that it needs to be a nonprofit and the volunteer needs to be doing volunteer work and not displacing a regular employee, those are a couple of very important factors. I will typically also say to you that the volunteer under Massachusetts law ought to be doing charitable work. So under Massachusetts law, a volunteer also should be doing charitable type work and not work that would otherwise be done by a paid employee.
Great, thank you. Another question came through regarding liability and workers' comp insurance. So someone asked, do participating mentors in mentorship programs, such as those funded by BFRDP grants, require their interns to be covered under the liability or workers' comp insurance?
I don't know the answer to that. So I take it that this is an individual who would come to you through some sort of an agency. And if that is accurate, if I heard the question right and I've got it right, what I would do if I were you is before permitting that individual to perform any work at your farm, I would ask the agency that brings that worker to you whether or not the individual is covered under a workers' comp policy that that agency or that organization has obtained. And I actually may go one step further and ask the agency or the organization for what's called a certificate of insurance, which is typically a single sheet of paper that will identify the agency or organization that is insured, the insurance company that insures them. It will list that they do have workers' compensation insurance, and it will have the limits of liability. In other words, the coverage that's provided under the workers' comp policy. And I would ask for that, and also a written representation that those folks who are being placed at your farm are covered under that workers' compensation insurance policy.
Great. Okay, so the next question is about more of a homestead caretaker situation. How would you advise a homestead farmer who's looking for a caretaker/tenant to provide some labor in exchange for reduced rent? How could labor law mix with landlord-tenant law, I suppose, to accommodate sustainable lifestyles, something more flexible?
Okay, so there's nothing flexible about the law. So that's sort of where we start from. But that said, you are permitted to deduct from an employee's minimum wage. So that means you've got to pay the employee a minimum wage. If they're covered by the agricultural worker exemption under Massachusetts law, that can be a sub-minimum wage. If they are not covered by the sub-minimum wage available for your agricultural worker, they need to be paid $11 an hour. But you are permitted to make deductions from an employee's minimum wage for housing and for meals. And as most laws are written, there are limits as to what you may deduct for lodging and what you may deduct for meals. And it's fairly insignificant. So you are permitted to deduct for housing in an amount not to exceed $35 a week for one person $30 a week for 2 people, or $25 a week for 3 people. And the lodging that you provide to your worker has to meet safety and sanitary and code requirements. With respect to meals, you are entitled to deduct from minimum wage an employee's meal. And the maximum rates are $1.50 for breakfast, $2.25 for lunch and dinner. And if your worker works for 3 or more hours a day, you can deduct for 1 meal. If they work for 8 hours a day, you can deduct for 2 meals. And then if you also provide that employee with lodging in addition to meals, you may deduct for 3 meals per day. So it's highly regulated. There is sort of no ability to do anything different than what I just indicated to you, notwithstanding the question and what I took from it, you're looking to accomplish. What I just said is what you're permitted to do, and honestly, nothing more.
Okay, great. And then another kind of particular situation. So someone wrote in, a young Boy Scout and neighbor wants to make some money for camp. If I have him do some odd jobs around the farm, do I have to sign him up as an employee and have taxes taken out?
So if he cannot be classified as a volunteer, I would say that you do have to pay him. That said, depending upon how old the individual is and what type of work the individual is going to do, it may be that you would be permitted to pay that worker less than a minimum wage because he may qualify as a child, and so the child labor rates are significantly less than the minimum wage rates of pay. So what I would recommend you do is Massachusetts has a really good, detailed, and easily understood website that is put up by the Department of Labor, the Mass Department of Labor, and they have a lot of frequently asked questions type of pages that I would go to and find out whether this young person would qualify as a child and whether you might be able to pay that person less than minimum wage.
Great.
And by the way, I would also say this to you, even though I'm not advocating this, my understanding, and I'm not a tax lawyer, but my understanding is that you are permitted not to have to report wages that you pay to a worker if they do not exceed a certain amount of money per year. I don't know what that level is or what that limit is, but if in fact this individual is only coming over and working a day here or a day there, if it's expected by you that they would not work enough hours to exceed that amount, that you don't need to report if they work under that amount, it may very well be that you could make some other arrangement.
Great. Okay, and this relates to ag exemption laws. So how does the agricultural exemption law treat employees who work both in the field, in farm stands, and or farm-based processing facilities?
So if you've got a worker that's essentially doing 2 types of work, meaning they're doing agricultural work that would otherwise permit you to pay them that $8 sub-minimum wage, and they're also working non-agricultural work that would otherwise require that you pay them minimum wage. So in other words, they're doing dual work. That gets very challenging for you because typically each worker has one classification. So they're either an agricultural worker or they're not. As a result of which, if you sort of blend the two types of work together, and you've got your agricultural worker doing true farm work, but you've also got them working, for example, at the cash register for the farm stand, which would not be agricultural work. Now you get into a situation of really what are they, and how frequently are they doing their non-agricultural work, and does it impact the classification that you are relying upon in order to pay them a sub-minimum wage? Because remember, your agricultural worker is eligible to be paid a sub-minimum wage of $8 per hour, and you don't have to pay them overtime. The non-agricultural worker is entitled to be paid $11 per hour, and they're entitled to overtime. So when you start to have the person perform dual roles, I would say to you that that's very challenging and potentially very difficult for you. I would recommend that you either contact the Department of Labor, Massachusetts Department of Labor, and see if you can get any guidance from them, or alternatively, don't have your agricultural worker doing non-agricultural work if you can at all help it. Because, as I said, your worker is entitled to one classification. You cannot pay them $11 per hour for their non-agricultural work and then $8 per hour for their agricultural work. They're either, they're not both. So I would be very careful about that. And if you can, I would simply have your agricultural worker sticking to the agricultural work.
Right, good distinction to make. Okay, another question. When does the agricultural minimum wage exemption apply?
So the agricultural minimum wage exemption, which is the sub-minimum wage that I've spoken about, it applies when you have an individual who is doing farm work or agricultural work. And we talked about that a little bit earlier. So it's labor on a farm and the growing and harvesting of agricultural, floricultural, and horticultural commodities. So if your worker is performing those types of services, they are an agricultural worker. And the federal definition is a little bit more robust, and it provides, I think, pretty good guidance as to what's agricultural work. So that is cultivation and tillage of soil, dairying, production, cultivation, growing, harvesting of agricultural or horticultural commodities, raising of livestock, bees, fur-bearing animals, poultry, and any type of work, including forestry or lumbering, performed by a farmer or on a farm that is part of a farming operation. It will not include working at your farm stand. It will not include making jelly or jam with berries that you grow and harvest, and it will not include things such as agritourism.
Great. And another question here, more in regards to apprenticeship programs. How do apprenticeship programs avoid discrimination charges based on physical capabilities while also ensuring that the apprentices are physically able to do the necessary tasks?
Well, that's a question that really applies not only to apprentices, but any worker that you may seek to employ. And as you probably all know, those persons with a physical or a mental disability are entitled to be employed and to work so long as they're able to perform the essential functions of their job with or without any sort of an accommodation to their disability. So what that means is if you've got a particular job that needs to be done and somebody has a physical or a mental disability, if you can provide them some sort of an accommodation that would permit them to do their job, that's what you've got to do. So whether your worker is an apprentice or a regular employee, if they present to you, let's say with an obvious disability, you need to determine whether or not that person, notwithstanding their disability, and with or without an accommodation, can nevertheless do their job. So, for example, if you had a person that applied for work as an employee or an apprentice and they're missing an arm, that's an obvious physical disability. And if you're going to hire them to pick vegetables, for example, you are permitted to inquire whether the person will need an accommodation in order to perform their work. If they say no, we don't need an accommodation, well, you have every right to expect that they will be able to perform the job that you've hired them to do, to pick the vegetables. They may say, yes, you can provide me with an accommodation, I do need one, and the accommodation will permit me to perform my job even though I'm missing an arm. Then the issue is whether or not the accommodation that you've been asked to provide is reasonable, whether you can in fact provide it, and typically that analysis involves a discussion between you and the individual. If it is a reasonable accommodation and you can provide it, then you do so. And always and everywhere, whether the disabled individual says they don't need an accommodation or they say they do need an accommodation and you provide it for them, you have every right to expect that they are going to do the job that you've hired them to do up to appropriate, reasonable standards. So you don't give that individual a pass, but you make sure that you have a dialogue with them as to whether or not they require an accommodation.
Great, thank you. I do just want to quickly mention, so we have about 5 or 6 more minutes left of the webinar, and there's a handful of questions that we received pre-populated from folks when they were registering. If anyone has questions, we've also been addressing questions that have come through the chat box by attendees throughout, but if folks have additional questions, now would be a great time to make sure to get them in. And if I may, call on my colleagues here, Sarah Dewey and Jenny Rushlow with the Conservation Law Foundation, in case there are questions coming through. If any attendees could send them to at least to all panelists, if not to all attendees, to ensure that they are seen. I am experiencing a little bit of technical difficulty on my end with the WebEx platform, so just to make sure all questions are heard, if you could send it to all panelists or all attendees, that will ensure it will come through to everyone. And so moving along to another question here, and this is more specific to apprenticeship and internship programs. What are current school farm partnership agreements for internships, paid and for credit?
So one of the benefits of having a program, an internship program, that will likely pass muster is to have it sponsored by or undertaken in conjunction with an educational institution. So if you could partner with either a college, a university, or a high school vocational program, then likely the intern program is going to pass muster, because typically folks want to employ, if you will, an intern and not pay them. And that's when you get into some difficulty. Under Massachusetts law, in order to have an internship, which is an unpaid internship, you do not have to pay that individual, but only if the internship program is a training program or a charitable, an educational, or a religious institution. So charitable, educational, or religious institution, and it's got to be a training program. So certainly, if you were to partner with a school or a university or a college that permits you to satisfy that criteria that is applicable under Massachusetts law. Now, Massachusetts law is much stricter than federal law, and federal law is much more lenient, but unfortunately, as I said at the beginning, if the Massachusetts law is a better deal for the worker, that's the law that applies. So again, if you have an educational institution that you partner with, that's going to go a long way to ensuring that your unpaid internship program passes muster.
Great. Thank you. And let's see, another question regarding classifying apprentices as employees. So this person writes in, our HR and legal team has determined that our apprentice farmers should actually be classified as employees. What do other apprenticeship programs do that are complying with the U.S. labor laws that enable them to run a program with non-employee classification?
I don't know, frankly, of any ability under federal or Massachusetts law to classify an apprentice as anything other than an employee. Now, as I indicated earlier in the program, if you have an approved apprenticeship program, you still are required to pay that apprentice minimum wage. You have the opportunity to pay them a sub-minimum wage if you obtain a certificate from the government agency that approves apprenticeship programs. But to answer the question as to whether you can have an apprentice that is not classified as an employee, not to my knowledge.
Okay, great to know.
Now, one thing that nobody did ask about, but I wanted to give folks the benefit of being aware of a seasonal business waiver. That's available under Massachusetts law. What it permits you to do is to hire a worker and to not be required to pay them overtime if you obtain a seasonal business waiver from the Massachusetts Department of Labor. Now, a seasonal business for which you can get a waiver for your workers is a business that is carried on no more than 120 days in a year. So if you have a seasonal business in its entirety, or your farming operation, for example, has a seasonal business component to it, you can very easily call up the Massachusetts Department of Labor on your computer. It's a fill-in-the-blanks form that you then submit with $200. Of course, they get a filing fee out of you, to the Massachusetts Department of Labor, and depending upon the nature of your business, you will be permitted potentially to get a waiver that would mean that you do not have to pay your seasonal business employee overtime. And a lot of people don't know about that seasonal business waiver. And if any part of what it is you do in your farming operations involves a seasonal component to it, for example, if you sell Christmas trees only at Christmas, you could get a seasonal business waiver potentially for the employees who work for you selling Christmas trees during that brief period each year.
Great, definitely good to know about. Well, in the interest of time, it's 1:01, and just want to wrap up here. We had a few other questions that had come in advance, but I think we have addressed them, mostly around minimum wage exemptions for farm apprentices, properly structuring on-farm apprenticeships to meet the needed requirements and employment laws. And then another question around nonprofits helping to facilitate on-farm apprenticeships for profit, which I think we addressed to a certain degree just in regards to setting up apprenticeship programs and having that educational component, being able to be classified as volunteer if you're working through a nonprofit entity. So with that, I'd like to thank our partners here today. Certainly thank you so much to Beth O'Neal for all of your input and answering all of these questions and lending your expertise. It's been truly invaluable to hear all of this information from you. So thank you so much. And also, also a huge thanks to the Conservation Law Foundation and the Legal Food Hub, to Sarah Dewey and Jenny Rushlow for your help today and for your coordination and facilitation assistance as well. So again, we'll be following up with some resources and information that will hopefully be good reference points for some of what we covered today. The recording of the webinar will be sent out, and also that evaluation and feedback survey, if you don't mind filling that out as well. And so thanks again to everyone. Thanks for all of your participation to the attendees, and we hope you have a great day.
Thank you all. Take care.